right, we will call the Senate Judiciary Committee to order. Will the esteemed secretary please take the roll?
Senator Harris. Senator Dondero Loop.
Here.
Senator Orenshaw.
Here.
Senator Wynn.
Here.
Senator Hansen. Senator Krasner.
Here.
Senator Stone.
Here.
Chair Scheibel.
Here. And would you please mark those senators who are not here yet present when they arrive? I am expecting both of them, though they did let me know that they had other obligations, as we've discussed many times in this committee at this point. So I think today we can finally dispense with all of the housekeeping. You all know the rules of the road, so to speak, of Senate Judiciary. And we have one item on a couple items on our agenda today. We will start with Senate Bill 14. Are our presenters here to walk us through Senate Bill 14? Excellent. I will ask you to take a seat up front. You already know this, but press the microphone button in order to speak. Give us your name each time you speak so that our wonderful secretaries can keep it on the record accurately, and we look forward to hearing from you.
Good afternoon, Chair Scheibel, Vice Chair Harris, and members of the Senate Committee on Judiciary. I am Kirk Hendrick, Chair of the Nevada Gaming Control Board, and also present with me today is Mike Morton, the board's Senior Policy Counsel. And I believe board members Brittany Watkins and member George Assad, along with chiefs of the board's various divisions, are available via telephone conferencing to the Grant Sawyer Building in Las Vegas. We are here today, as you noted, to present Senate Bill 14. SB 14 seeks to make various minor changes to Chapter 463 of the Nevada Revised Statutes to more efficiently handle the board's licensing process that is essential for the regulation and success of the gaming industry. With the chair's permission, I will first go through the bill by topic area and then present remaining portions of the bill that the board is seeking to amend with the conceptual amendment that you should have before you. The first topic the board would like to present in SB 14 is in Section 2. Currently, if the board determines that a debt owed to the state by a licensee or former licensee is impossible or impracticable to collect, the board must make a request to the State Board of Examiners to designate such debt as a bad debt. Upon a vote of the Board of Examiners to designate such an amount as a bad debt, the state controller is then directed to remove the bad debt from the books of the state, although it remains a legal obligation owed to Nevada. Section 2 of SB 14 would streamline the process to designate bad debt by reorganizing those steps of the process. The proposal would allow the board to determine if a delinquent debt is impossible or impracticable to collect and would authorize the chair of the board to notify the state controller of such determination and remove the debt from the books of the board. The state controller would then seek the removal of the debt from the books of the state before the Board of Examiners. Section 11 makes a conforming change to effectuate the proposal. The board is requesting this change to more efficiently close out its books for each fiscal year. It's important to note that the board rarely utilizes the bad debt removal process. The last time the Game Control Board went before the Board of Examiners was in 2019, and that was for the amount of a designation of approximately only $800 of bad debt. For the last fiscal year of 2022, the board collected nearly $1.2 billion in taxes and fees, and this time will be seeking a Board of Examiner approval to remove only $1,035. In other words, an uncollectible tax of only 99.99% collected and 0.001 uncollected. 0.0001 uncollected is less than 1/100%. So because gaming license is a privileged license, the board has broad authority and tools to collect gaming taxes and fees. Therefore, by the time the board currently seeks a bad debt determination from the Board of Examiners, it means there's almost at that point practically no chance of collecting that small amount of uncollected debt. Consequently, Section 2 efficiently administers the board internal accounting with the state and without having to go through a process that slows down the collection or the uncollection of that small minor amount. The next topic in the bill is SB 14, Section 7. NRS 463.373 is the statute that imposes a quarterly slot tax on restricted licensees based on the number of slot machines being operated. The new language in subsection 5 of section 7 requires those who receive a share of revenue from the operation of slot machine revenue to pay that person's proportionate share of the quarterly slot tax. This proposal would make consistent the various statutes regarding quarterly fees and annual slot taxes when proportional shares of license fees are involved. The newly proposed language already exists in NRS 463.375, which imposes non-restricted quarterly fees, in NRS 463.385, which imposes annual slot tax. Therefore, this proposal would make consistency for the imposition and collection of all slot taxes imposed by the state. The proposal would not change the amount of quarterly slot tax collected by the state, but would ensure that each licensee is responsible for paying the accurate share of their tax. Turning to Section 8 of SB 14, currently NRS 463.386 authorizes the chairs of the board and the Gaming Commission to administratively deem certain licensees upon transfer what has been called a continuing operation. This allows the transferee to collect prepaid taxes and fees from the transferor. The board is proposing the addition of various licenses to the administrative approval process. For purpose of the record, I will recite the proposed licenses to be added and their requisite fees. NRS 463.450, the disseminator license tax, is 4.25% monthly. NRS 463.660, manufacturer and distributor licenses, $500 annual fee. NRS 463.667 is the interactive gaming service provider license, that's a $1,000 annual fee. NRS 463.760, manufacturer of interactive gaming system license, $125,000 initial fee, $25,000 annual fee thereafter. NRS 463.765, interactive gaming licensee, $500,000 initial 2-year fee, $250,000 initial annual fee thereafter. And finally, NRS 464.015, operator of parimutuel system license, is a $500 annual fee. Because these fees are not refundable, the state would see very little, if any, loss in transferred taxes or fees, and only if existing operations are actually purchased by another individual or entity, and then only if the chairs of the board and commission deem there to be a continuing operation. So it's a very minor change that should streamline the process. And this change will treat all types of relevant licenses the same and would save the board time and resources. Currently, multiple licenses are held by one licensee, which could be treated differently. So the system right now is cumbersome, and the companies are reviewed and audited by either the board's audit or tax and license division on a regular basis. Consequently, the board and commission are confident in deeming transferred licenses as those that are only continuing operations when appropriate. Now I'd like to turn to the proposed amendment submitted by the board and outlining the rest of the bill for you. I came onto the board approximately 2 weeks ago, and after having reviewed the proposed SB 14, there are a few changes I would like to make, and so those you'll see in front of you with help of obviously the board staff. As written in SB 14, Section 1 would grant the Nevada Gaming Commission authority to adopt regulations allowing the chair of the board to administratively approve a spouse, next of kin, personal representative, guardian, or heir of a licensee who is deceased or has been judicially declared disabled to temporarily engage in certain gaming operations without first obtaining a state gaming license. After further review, it appears that the rationale for the proposed amendment does make sense, but the process is slowing down a family once they've lost a loved member of their family, and probably the last thing they're thinking about when they lose a loved one is filing paperwork with the Gaming Control Board within 30 days of such a death or disability, and to get an application for temporary licensure to operate a gaming operation that maybe they were involved with, or maybe they were very littly involved with. So the application, once currently goes through the board's rigorous application process, just like every other application that comes before the board. And as I stated, that's a long process for somebody who's dealing with the death or disability of a loved one and not thinking about gaming regulation. So the idea here has been that oftentimes these families will have to come before the board or commission, and at the same time the board and commission members are expressing sympathies to the family on the loss of their loved one. At the same time, simultaneously, they're having to state that there's been a violation of Nevada gaming statutes and that there could be disciplinary action. It's a troublesome position for anyone to be in and not good for anyone involved in the matter. So this would allow the licensee's estate to more efficiently administer the disposition and closing of the estate while still complying with all applicable gaming laws and not having an unlicensed individual conducting gaming operations in this state. Sections 3, 4, and 9 make conforming changes to NRS based on the proposal in Section 1. Turning now to Sections 5 and 6. As proposed in SB 14, Sections 5 and 6 would have changed the locations for judicial review and declaratory judgments for gaming-related matters. The intention was to expand the availability of judicial review for those individuals or entities that may no longer reside or do business in the state, but they may still have pending matters, administrative or legal matters, here in the state of Nevada. Upon further review, the board realized that the language as written in Sections 5 and 6 would have actually limited the locations of judicial review. Therefore, the board has submitted the proposed amendments to Sections 5 and 6 to more accurately reflect the board's intention. And lastly, the board would like to explain the proposed changes to Section 10. Currently, unless certain limited exceptions apply, a former state employee who is collecting benefits from the Public Employees Retirement System cannot be concurrently employed by the state. While certainly understanding the justification for that prohibition, it has posed a unique problem based on the gaming regulatory structure here in Nevada. As all of you know, gaming in Nevada is a two-tiered system, the Nevada Gaming Control Board and the Nevada Gaming Commission. While the three members of the Gaming Control Board are all full-time employees of the state, the members of the commission are part-time employees entitled to a statutory salary defined in NRS 463.026. Pursuant to the prohibition, a former state employee who may be appointed to the commission would be unable to keep collecting his or her benefits under PERS while also earning the statutory salary of a commissioner. In finding the most qualified people to serve on the Nevada Gaming Commission, one place a governor may look is to the former government employees who have vast amounts of expertise in gaming, accounting, law enforcement, and other areas. However, due to the prohibition against earning a state salary while also collecting PERS, it is not feasible for that retired employee or local employee to collect their PERS while also earning the statutory, as it's currently defined, $40,000 per year. The board proposed Section 10 to provide a very narrow exception to prohibition. However, upon discussion with members of PERS, and I believe some of them are here in the audience today, they pointed out a much simpler solution, which was an amendment to Chapter 286 of the NRS. The board thanks the PERS staff for its help in finding this solution, which works both very well for the board and for PERS. With that, I want to thank you, Chair Scheibel, Vice Chair Harris, members of the Judiciary Committee, and that completes the board's presentation on Senate Bill 14. We'd be happy to answer any questions that members of the committee may have.
Thank you so much for your presentation. Are there questions from members of the committee? I'll start with you, Vice Chair Harris.
Thank you, Chair Scheibel. I have a couple of questions. I hope that's okay, so just bear with me, guys. Let's start with the proposed amendment for Section 1. Can you explain a little bit about why it needs to be in the chair's absolute and sole discretion as opposed to having the board adopt some regulations that I guess theoretically could give the chair sole and absolute discretion if that's what the board so chooses? Why the change?
Through the chair to Vice Chair Harris.
You can go directly.
Thank you. Appreciate that, Chair. Yes, Vice Chair Harris, again for the record, Kirk Hendrick. The reasoning here was if you'd gone through the regulatory process, it probably would say exactly the same thing that it says in this one paragraph. There's quite a few statutes and regulations under NRS 463 and the Nevada Gaming Commission regulations that say the same thing. The chair shall have sole and absolute, or sometimes it just say sole, sometimes it says absolute, sometimes it just says shall have the discretion to do such a thing. The key here was speed, and if there was a regulatory process, it would be given to the chair of the board anyway because it's temporary. And almost every temporary regulation goes to the chair of the board while the process actually goes through for full licensing. Or in this situation, some of these people don't even get fully licensed. They temporarily license it and the estate ends up selling the portion of the deceased or disabled person's estate.
Is it fair to summarize your answer as they'd probably end up here anyway?
Again, for the record, Kirk Hendrick, yes, it would end up being, in my opinion, after the regulatory process, it would end up saying that the chair shall have sole and absolute discretion for a temporary license for people only, as you see here, it's a very limited subset of people, only in the circumstance of a temporary license, only till the full license is done. So it's very narrow. It would end up saying the same thing.
Okay. Are you aware of any other commissions where the appointed commissioners are exempt from the collecting PERS requirement?
For the record, Kirk Hendrick, I am not, as you'll see in the amendment to that statute, it does references retired judges, but I'm not. I would have to probably defer that to PERS because they were the ones so generous of pointing us to that direction to begin with.
All right, thank you. I would just suggest the issue that you raised is probably true for lots of commissions in the state, right? Not just the Gaming Commission. Anyone with a substantial amount of experience who used to work for the state would not be able to come and be on a commission if they did not want to lose their ability to collect PERS, right? And so I guess I'm trying to figure out if there's some additional reason why we need to fix this for the Gaming Commission as opposed to fixing it for everybody or leaving it broken for everybody.
Kirk Hendrick, again for the record, the one thing I may add, and of course I would certainly defer to PERS and the LCB if they could find that, but the one thing that's a little different for gaming commissioners is that their statutory salary is $40,000, or in case of the chair, I believe it's $55,000. There's very few boards and commissions throughout the state that actually make over the $6,000 limit for financial disclosure, but again, certainly would defer to them if there's others that make sense.
Okay, I think that's all my questions, Madam Chair. Thank you so much.
All right, any other questions? All right, Senator Stone.
Thank you, Chair. Thank you for the presentation, and congratulations on your new position and your grasp of certainly the commission. When you have a continuous operation, somebody passes away, is there a time limit that this temporary license continuous operation can go on? And is there any type of a background check that's required? Obviously, you have some corporations that obviously have a succession plan, but being the father of an attorney that does wills and trusts, you'd be surprised how many people of significant wealth don't even have a will or a trust, and it can leave a lot of uncertainty. So I was wondering how you handle those types of situations.
Again, for the record, Kirk Hendrick, thank you, Senator Stone. And yes, you're absolutely right. There's a lot of paperwork, both on the probate side and on the gaming side. And as you'll note in Section 1, Subsection 1, it refers to, Section 2 of Section 1, it refers to must be limited to such time as the chair determines is reasonably necessary to settle the estate. Sometimes these applications currently take several months. And the idea here is you're ending up with nobody who's actually licensed for several months, which is not a good regulatory scheme. So this would fill in that gap.
I have a quick follow-up to that. You just pointed us to Section 1, Subsection 2, but it looks like in the amendment, Section 3 of Section 1, Subsection 3 of Section 1 becomes Subsection 2. So I want to make sure that we're all looking at the same language when we're talking about what happens in the case of the death of the license holder.
Kirk Hendrick, for the record. Thank you, Chair. You caught a very good point. So in order to streamline some of the wording, 2 was actually put into 3, but you'll see the key word there is still limit. In terms of gaming regulation, limit is usually defined as time. Conditions are usually in time, terms of things added to somebody's license, but it can be limited for administrative approval and would be still for the specific time period needed to fill the gap that I was speaking to Senator Stone about.
But it doesn't exactly say that in the amended version. It just says limit an administrative approval issued pursuant to subsection 1 in any manner the chair deems necessary and appropriate. So it's not limited to the time period of the settling of a probate matter. Am I reading it wrong?
Kirk Hendrick, for the record, no, you're absolutely reading it correctly. It's to provide more limitation for the board chair instead of just tying it to the time reasonably necessary to settle the estate of a licensee. This would give the board chair more discretion. Not only would you limit it for that time, you could say, and I'm also limiting it if you don't get a representative in place, if you don't do this in time, to actually speed up the time, or in certain cases, if there was a pending probate matter, the chair could actually extend it a little bit. But the actual true application process is going on in the background as well, usually takes several months. Wouldn't go past that.
Okay, thank you. Senator Dondero Loop.
Thank you very much, Madam Chair. I have a couple questions sort of on that same area, and that is, the first question is, has this happened in the past? Like, are we fixing something, or is this just like we decided to anticipate in case this happened?
Kirk Hendrick, for the record. No, absolutely, this happens a lot. My first board meeting was a week and a half ago, and it happened on my very first board meeting. A family up in northern Nevada had lost their father, who was the patriarch of the family. The 2 children were aware of the business but weren't really involved in it, and so this absolutely happened. They didn't know that they had to get application filed within 30 days. They didn't know about the process. They weren't really involved in much in the gaming operation, and so during that time period where they didn't know, they didn't file the proper paperwork, there was nobody licensed to operate that gaming establishment legally, and then they had to come in front of the board and do exactly what I said, which was myself and the other board members apologizing for the fact that we were there with our sympathies, but at the same time, they were in violation of Nevada gaming statutes and regulations, so it happens quite a bit.
Follow up? So I understand that, but what boggles my mind a little bit as a non-lawyer is at the gaming establishment, there's got to be lawyers, CFOs, people in charge, and nobody says, oh, by the way, we're not licensed anymore. I mean, that's to me almost a bigger problem, that somebody at the gaming establishment isn't walking forward with that. And on top of that question or that comment, what happens now? I understand that you're saying they don't know to file, but what happens? What's the end result? So my family has a gaming license, I pass away, my daughters don't know anything about it. Nobody at the gaming establishment is responsible enough, by the way, to say, oh, wait a minute, we need to do this, which if you've hired lawyers that don't say that, that's a bigger problem. And then what happens?
Kirk Hendrick, for the record. And yes, you're absolutely correct. Somebody should be paying more attention, but a lot of times these are small operations. These aren't non-restricted casinos in Reno or Las Vegas on the Strip. These are small operations, and although it is their legal responsibility to do it appropriately, a lot of times the person who is owning and operating the actual casino, their family might not have been involved, and so there was nobody there to do it. And without in any way besmirching the probate bar, they just generally don't know that this is required within 30 days. And what happens is either a good probate lawyer notices it immediately and gets it filed, or they notice it after 30 days. And through the probate process of trying to transfer ownership or officers and directors, this absolutely pops up, and then we end up in the scenario that I mentioned. But yes, somebody should be watching what's going on. It just doesn't always happen, and that's why they end up potentially facing disciplinary action.
So is it just discipline, or is it they close down?
Kirk Hendrick for the record. Normally what happens is if the family wasn't really involved in the gaming operation, they would be trying to sell it. And as part of the probate process, this would be along with other real estate, other assets of the owner's estate. This would be something they'd try to sell. Every now and then they want to keep it, but if they weren't involved enough to know that they needed to be licensed to begin with, they're normally trying to sell.
Thank you.
Other questions? Senator Wynn?
I know when I first read this, I just kind of assumed all like big casinos and people with major like stakeholders in like with gaming licenses. But this also includes people that have like gas stations and a single machine or like a couple of machines. Is that my correct understanding of that?
Kirk Hendrick for the record. Yes, Senator Wynn. The item we had on our agenda a week and a half ago was actually somebody who had 4 machines at a laundromat. And so the laundromat was owned by their father. They were aware of it, but they weren't involved in the operation. And so you're right. This would be convenience stores. This would be small bars throughout the state in some of the very small cities. And the relatives might not even live in the same city, so they wouldn't know about it.
And then as far as like major stakeholder, I'm sorry, Chair, may I follow up? As far as other, I guess, I think a lot of times we think of people owning, a significant percentage of like whatever the gaming license is, but there are times where people own like less than 1%. Is that correct? And they still have to go through that, and this would kind of eliminate some of that hassle for some of those, I guess, smaller stakeholders and smaller businesses that maybe don't have a team of lawyers?
Kirk Hendrick for the record. Yes, correct. And so a scenario where a closely held entity such as an LLC, even if somebody owned 1%, they would have to be licensed. And if that member were to pass away, luckily in that scenario, the other 99% usually do have lawyers, or they will be the ones to step up and immediately file an application with the Gaming Control Board within the 30-day time period. Sometimes it doesn't happen. And so, yes, you would want to fill that gap again so that we don't have unlicensed people operating gaming establishments.
And then my final question is has there ever been a consideration to require licensees to have succession plans so you wouldn't have this kind of like problem after the fact?
Kirk Hendrick, again for the record. That's a great question, Senator. I don't know the answer to that, if that's required or not, but it's certainly a good idea.
All right. Any further questions? Senator Stone?
Thank you again, Chair. So what if you get let's say you have a death, and, there's a lot of small casinos, and especially rural areas of Nevada. And so what if you get a, unqualified beneficiary? Let's say you've got somebody that's got a felonious background or has some other elements that they know nothing about the industry. Would you allow them to use a reputable casino management company as the interim licensee in order for them to find a buyer or take over the operation?
Kirk Hendrick for the record. Yes, Senator, that situation can come up. There's a whole bunch of variables that can happen as to, is it just one person who's the representative? If that was the case, and then you temporarily allowed them, even under this amended statute, you would say to them, you're not going to get licensed. We need to put somebody else up right now. And again, they would be trying to sell the operation. So in that situation, you would be trying to move the processes forward as rapidly as possible to somebody who was reputable and could get through the licensing process.
And just a quick follow-up. My only concern is that if you have somebody that's not intimately involved with the business and you get them in there, and you made it very clear in this bill that you're going to hold them responsible and cite them if they're not following applicable gaming laws in Nevada, they could get themselves in a lot of trouble. So that's why I was wondering if they could basically defer to a professional gaming company as their agent, if you will, that knows the laws and knows how casinos need to be run in compliance with Nevada laws and can get them to the end point. Thank you, Madam Chair.
Kirk Hendrick. Again, for the record, yes, that could happen. More likely what you would do, the enforcement agents and the other agents of the Gaming Control Board are so well versed at these statutes and regulations that they would know after a cursory check that if somebody had no idea about running a gaming establishment or didn't have the background credentials to do it right, the approval from the chair, even on a temporary basis, would go to a representative who did. So we would say to them, myself as a chair, I would personally say to them, you need to get involved, a representative for the estate who has a gaming experienced background in order to even get through the probate process. Thank you.
All right. Any further questions? I'm not seeing any questions. Thank you very much for presenting your bill to us. We will move now to testimony in support of SB 14, starting with anybody in person in Carson City or Las Vegas. I would ask that anybody who wants to testify in support make their way to one of those tables. I'm not seeing anybody, so we will go to the phone for testimony in support of SB 14.
Thank you, Chair Scheibel. The lines are open and working. However, there are no callers wishing to offer support of SB 14 at this time.
All right, then. We will move to testimony in opposition to SB 14. I'm not seeing anybody coming to the table here or in Carson City. So we'll go to the phones.
Thank you, Chair Scheibel. The lines are open and working. However, there are no callers wishing to offer opposition to SB 14 at this time.
All right, then we'll move to testimony in the neutral position. I do see some people coming down to the table in Carson City. I will let you guys go first, and you will each have 2 minutes to speak.
Thank you, Chair Scheibel and Vice Chair Harris and members of the committee. Good afternoon. My name is Cabrina Fazer. I'm the Operations Officer for the Public Employees Retirement System of Nevada. With me today is Ian Carr, our General Counsel. I just wanted to put on the record that staff would have recommended the Retirement Board oppose Section 10 as it was previously written because it poses potential Internal Revenue Code issues with optional participation. However, with the amendment, staff will recommend a neutral position to the Retirement Board on Section 10, as requested by the Gaming Commission, to provide a reemployment exemption to gaming commissioners in NRS 286-520 subsection 7, and does not amend any other provisions of the NRS Chapter 286. The reasoning for this is we recognize the unique circumstances of the gaming commissioners, and the exemption would only apply to a very limited number of people. Reemployment provisions are cost containment features to the system, but this extremely limited exception should not impact our costs. We note that under this section, there would be no right to re-enrollment in the system if a commissioner is appointed under the reemployment exemption. In addition, we also just wanted to put on the record that there is a potential Internal Revenue Code issue if there is not a bona fide separation of employment. The board has authority to develop policies to ensure a bona fide retirement to ensure Internal Revenue Code compliance. If the amendment could include changing person to retired employee in the first instance of subsection 7 to mirror all of the previous subsections, this would make Internal Revenue Code compliance more clear. And if there are any questions, I am happy to answer them at this time.
Thank you. We don't always allow questions for people who are testifying, but at my discretion, I will allow it in this case because I do think it will help the committee to come to a decision about the bill, and I know that Vice Chair Harris has such a question.
Thank you for your misplaced faith, Chair Scheibel. Do you all have recommendations on other commissions where maybe we want to give them an exemption since we're here looking at it? I don't know if I'm convinced that the Gaming Commission is actually differently situated than a lot of, we have 1 billion boards and commissions here. So are there others that you think this might be beneficial for that we could consider at this time?
Vice Chair Harris, if I could go direct. Sorry about that. Yes, so there are already reemployment exclusions, you could say, for people who are appointed or elected to public office. In addition, a lot of the smaller commissions wouldn't qualify because they're going to be underneath our earnings limitation. The difference here is the $40,000 for the Gaming Commission is above that earnings limitation. So we would really like to thank Chair Hendricks and Councilor Morton for being able to meet with us and work through this. But that's one of the key components that makes the Gaming Commission. They are paid a salary, but it is above that earnings limitation. And so that might be one of the reasonings that makes them unique.
So is it fair to say you think Gaming Commission's the only one that will have this problem? Or are you advocating for a lower salary? I'm kidding on the second part. Don't worry, guys.
We could always, we could do some additional research to see if there's any other, but we have not been aware of any other than the ones listed in that statute, which is the Legislative Council Bureau, and also the senior justices. And that was brought in 2019 was whenever that was revised. So no, we haven't had any other reemployment commissioners be brought to our attention.
I'll just say quickly in closing, sometimes people don't know that what they need to do is ask. And so, I would encourage you all to do a little bit more research and see if you think there's somebody else who has the same problem but doesn't have the, let's say, same knowledge or get up and go to come to you all or to have a bill draft put in. And maybe we can help those folks out too while we're here. Thanks.
And if I may, Chair Scheibel, Cabrina Fazer for the record, I just wanted to also make you aware that any reemployed retiree does have there's a dual notification with a public employer. So anybody who's working as a reemployed retiree in the public sector, they need to notify PERS within 10 business days. And then also their employer is also required regardless of the capacity. And so we do have that in place. And so that's what I mean as far as we haven't heard of any other similar instances because we do have that notification process in place.
All right. I don't see any other questions. So did you also want to provide comments on the record? All right. I'm getting a no. And I don't see anybody else coming to the table either in Carson City or Las Vegas. So we will go to the phone for testimony in the neutral position on SB 14.
Thank you, Chair Scheibel. The public lines are open and working, but there are no callers wishing to offer neutral testimony at this time.
All right, then. I will invite our presenters back to the table to give any closing comments if you wish, but it's absolutely not necessary. Okay. Sometimes there are things that we want to clarify or things people want to respond to, but in this case, I think we have covered everything very thoroughly, and I appreciate the participation of the members of this committee as well as all of you. And at this time, I am prepared to close the hearing on SB 14. That takes us to the next item on our agenda, which is public comment. Is there anybody in person in Carson City or Las Vegas wishing to make public comment? I don't see anybody coming to the table in either place, so we will go to the phones for public comment.
Thank you, Chair. The public lines are open and working. However, there are no callers wishing to offer public comment at this time.
All right, then. I will go ahead and close public comment and wish you all a very happy Valentine's Day today. We will not be having a judiciary meeting tomorrow. We had planned on one, and we've since revised our schedule to cancel tomorrow's meeting, as well as Thursdays and Fridays. So this is our last meeting for this week, but we will be back on Monday, ready to go at 1 p.m. We'll have a full week full of hearings next week, and we look forward to seeing you at that time. Until then, we are adjourned.